Um, Great, thank you, Jennifer. So first of all, thank you for joining today. This may be the last meeting of our, I think now 2-year working group. So I want to begin just with giving my thanks to everyone who has participated throughout this process. I think we've reached a great result. I might be biased in not giving my role in the process, but I think we've reached a great result and appreciate all your hard work throughout that process. So I do not anticipate today's meeting will take the full hour and a half that is scheduled. My plan for today is to share my screen with you. We can just go through the comments I have received from several of you. Maybe resolve most of those now. And then my plan is I will circulate the draft handbook to the entire working group after today's session for a final review, and then we can hopefully vote by email and conclude this process. So let me share my screen now. Great, is that visible? Perfect. So first of all, before I go into the comments I've received, are there any comments from anybody on the line or any general comments that anybody would like to share? Great, then let's march through. First of all, just a note for everybody on the call, and I'll reiterate this in an email afterwards. I have listed the members of the working group along with their affiliations as I have them listed currently on the webpage for this project. Before we publish the final handbook, please just take a look, make sure names, affiliations are correct. If any agency members would like to list alternates who participated as well, that's perfectly acceptable as well. So just let me know. So with that, let us march through. The first comment comes from Noelle Green from the EPA. She mentions that at various points we refer to an internal rulemaking record, at other points just the rulemaking record. For clarification, recommendation 2013-4 from ACUS refers to a rulemaking record. In various conversations, we had emphasized that this is an internal record. I think Noelle has taken the stance that drawing that distinction between internal and external records is quite useful. Is there any opinion on referring to the internal rulemaking record throughout the handbook in lieu of just the rulemaking record? If not, Matt or Reeve, can I get your opinion on this actually? I mean, obviously 2013-4 refers to a rulemaking record. I think it's quite useful to refer to an internal rulemaking record. Do either of you have any concern from an ACUS perspective in just using the term internal rulemaking record?
No, no, and I think that given the way you've structured the document, it would probably be too disruptive to make a change anyway. But no, I don't think a change is necessary. Reeve?
I agree. I think that's
Perfect.
exactly right.
Perfect.
Because you need some term here, and so I don't know that there's a better one.
Right. I think rulemaking record is a useful one. Whether we want to call it the internal rulemaking record throughout and just be consistent throughout is the main point here. I think the term internal is useful just to emphasize to agency personnel this is an internal record. There are no concerns about including privileged information, for example. But if anybody has any strong objection to adopting for the phrase internal rulemaking record, I guess speak now. Great, so we'll go with internal rulemaking record. In the second paragraph, a few small stylistic things here referring to policies and procedures, adding in practices. If there's no objection to those, I will adopt them. Noel also had another point that it's very likely that federal regulatory agencies already have guidance outlining policies and procedures for engaging in informal rulemaking. To the extent that ACUS intends to address that topic in this handbook, ACUS should consider acknowledging that agencies should follow their existing guidance, policies, and procedures on the issue. My hope was that that was implied throughout. Of course, we're not necessarily that agency personnel should follow the rules that their agency have prescribed, but I think we can add a sentence in that makes this clear at this point. Stylistic change from concepts to subjects. The handbook identifies the key subjects the guidelines should address. For these stylistic points, I will go through, and if I think they're stylistic, I'll accept, but if you have an objection, just speak up and let me know. Great. So at 1.2, a number of stylistic things here as well, changing people to agency personnel, rulemaking projects to rulemakings, are to maybe, some may be new to informal rulemaking, and making the last part of the last sentence a standalone sentence. There are no objections to those. I will accept them. The larger point for this paragraph that Noel has raised is the handbook describes the audience for agency guidelines as agency personnel who are involved in rulemaking, which could include policy specialists, scientists, economists, lawyers, rule writers, communications and public affairs specialists, administrative staff, and others. However, the sample language, which appears throughout the handbook, seems geared towards rule writers, which could be perceived as a disconnect. While the handbook also suggests that agencies should be mindful of the needs and responsibilities of their audience when drafting guidelines, it may be helpful to add a disclaimer to the sample language that reiterates that point. Any thoughts from anybody on today's call as to whether the sample language is too geared towards rule writers, if there's any language we should include to ensure that it'll be accessible to other potential audiences within agencies who work on rulemakings? Great. If not, I will put a pin in that for now, but if anybody has any thoughts on that as we move through the document, just speak up. This is a minor stylistic change, changing these groups to the pronoun them. All right. So here, in this section, ACUS recommends that all agencies aim to answer 7 basic questions in their guidelines. These 7 questions are based on recommendation 2013-4. They're not verbatim, they're phrased here in the form of questions versus the sort of language that ACUS tends to use in its recommendations. The original text here was, what materials should personnel exclude from the internal rulemaking record? And including guidance on whether and when to exclude materials such as personal notes or draft documents. Noel asks, by rulemaking record, is question 2 referring to the internal rulemaking record alone or all 3 types of rulemaking records? The question seems to be relevant to the docket and administrative record as well. I would note that 2013-4 refers only to the internal rulemaking record in this question. I agree, these questions are more broadly relevant. Are there any thoughts on expanding this or leaving it as simply the internal rulemaking record?
This is Megan. I think I would agree with expanding it because the answers are going to be very different, obviously, for each category. So I think it's worth keeping it fleshed out and emphasizing that you need to think about them in different ways.
Great. Thank you, Megan. Any additional thoughts? Great. Is there any objection then to expanding it and accepting Noel's language? Hearing none, I'll accept it. These last two, 6 and 7, are mostly for parallel structure. Questions 1 through 5 are phrased in terms of what should personnel do. 6 and 7 are reframed to follow that same format. Unless there's any objection, I will accept those changes. Throughout the document, I think I prefer to agency leaders. Matt, I think you suggested changing agency leaders to agencies. Is there any objection to making that change here and throughout? Hearing none, I will adopt that, and we'll make corresponding changes throughout. Few more grammatical and stylistic things here. Throughout, I have referred to rulemaking projects. Is there any objection to changing rulemaking projects to rulemakings? Hearing none, I will accept these changes and again make conforming changes throughout. Moving into chapter 2. This chapter outlines sort of fundamentals of what informal rulemaking is and how it works. Noel had a global comment about this chapter. The handbook is intended to provide agencies with guidelines to follow when developing guidance on compiling and maintaining the various kinds of informal rulemaking records. Chapter 2 on rulemaking fundamentals tackles the broader informal rule development process, which seems to address a larger issue that may be out of the scope of this effort. Again, I might be biased here, seeing as I drafted this. My own view is that it's difficult to talk about these different records without tying them to steps in the rulemaking process itself. I think guidelines that talk about internal records, public rulemaking dockets, and administrative records for judicial review need to be tethered to concrete steps in a rulemaking process. And several guidance documents seem to take that approach as well. Were there any other concerns about chapter 2 generally, or specifics about how it's drafted? All right, hearing none, we will leave it for now. Here we have sample language for what is informal rulemaking and how does it work. Noel notes that additional informal rulemaking requirements, this section outlines that requirements for informal rulemaking are set forth in the APA and in court decisions that interpret it, as well as in White House directives, especially EO 12866, and in agency regulations. Noel adds additional informal rulemaking requirements are in other statutes, such as the Clean Air Act, Clean Water Act, and Regulatory Flexibility Act, as well as executive orders and agency regulations. Is there any objection to including procedural and substantive statutes? For example, the Reg Flex Act and the Clean Air Act is obviously relevant to EPA and not so much elsewhere. Any thoughts on this language? I think it's certainly true that the Reg Flex Act is relevant. Is the term procedural and substantive statutes clear to others on the call? I think my only concern then would be then the reference to Clean Air Act. Obviously, that's relevant to one agency, but not necessarily others. Any objection to removing Clean Air Act and retaining the rest of Noel's proposed revision?
Yeah, I would take out the agency-specific references here and probably elsewhere.
Right. Great. Otherwise,
Unless you're quoting an example of something,
Yeah.
that's a different story. But
Absolutely. And I will, yeah, note throughout the handbook, these sort of blue boxes are sample language that I've drafted based on our conversations throughout this process, whereas the green boxes just quote verbatim from existing agency guidance. So in this one where it's just sample language, we can leave it as procedural and substantive statutes, for example, the Right Flex Act.
I actually think the Clean Air Act might be helpful to sort of highlight that agencies should look to their own substantive statutes.
Okay. Other thoughts?
I mean, I think if you're going to leave in procedural and substantive, I would give an example of each.
Sure. And does this do the job for you?
Yeah, yeah.
Great. I presume, you at the NLRB are not going to be confused by seeing a reference to the Clean Air Act and think suddenly you're subject to the Clean Air Act.
We'll do our best.
That works. Perfect. Matt, can you live with that?
Oh, yes, of course I can live with it.
Perfect. So hearing no objection, otherwise, unless there are other thoughts, I will go ahead and accept that language.
And by the way, I'm just speaking as a member of the working group and offering my opinions here.
Great. Here, there's a sentence that reads, or it did read, along with the proposed rule, you will draft an introduction called a preamble that describes the proposed rule, the legal authority of the rule, and opportunities for public participation in the rulemaking process. Noel writes, to the extent ACUS wishes to give a very general overview of what a preamble contains, the description should be clear that the elements outlined are not an exhaustive list. Is there any objection to including among other things? Hearing none, I'll accept that. Great. This is stylistic capitalization, unless anybody is very wedded to capitalizing advance notice of proposed rulemaking request for information. I will accept this change.
That's just my quibble. I'm sorry, Jeremy. These are just not proper nouns and I don't understand one.
No, that's perfectly fair. Great. Under section 2.3, this paragraph rather, originally read, after developing a proposed rule, the agency must provide public notice of the proposed rule and invite public comments. The guideline should explain that the agency must publish an NPRM in the Federal Register, which includes the text of the proposed rule and the preamble discussed in the preceding section. Noel has recommended adding in unless an exception under the APA applies in two places here. That's obviously correct. Any objection to including that language? Hearing none, we'll accept. Great. Stylistic as well. Changing a can to a may. And stakeholder groups to stakeholders. Matt, I think you raised this building on Noel's comment earlier, just again, adding another unless an exception under the APA applies. Any objection to this language here? Hearing none, I'll accept. Changing White House to presidential and OMB directives. I think this appears in several places throughout. Is there any objection to that? Great. All right. Stylistic. All right, hold on, that skipped a bunch. All right. the recommended change here is the original sentence was, if the agency decides to issue a final rule, personnel must consider all public input and draft the final rule and a preamble that explains the final rule and responds to public comments. Any objection to adding in the word significant?
Jeremy, could we maybe do something like relevant public comments or something instead of significant? I think significant, I think that maybe narrows it a little bit more than we would want. I would think relevant is the 553 standard.
Sure. Any other
Reeve,
thoughts?
I'll take blame for this. I'll take credit or blame for this change. And I don't have any objection to your characterization here. The reason I think I use significant is I thought that's what we used in the preamble of, I don't know if it was mass comments, and we were trying to characterize the case law and judicial review. So maybe just when we all review this again, we could just take another look at it. That's the origins of it, but it could have been my faulty memory.
Yeah, good point.
Yeah, I thought the standard was significant public comments in terms of at least what's required under the APA.
I mean, I think it says take into account the relevant matter presented. I think is the exact language.
Okay.
Part of this, Reeve, is we may be coming from two different angles. One is you're coming from the APA. I'm coming from the court's perspective and the gloss the courts put on it. I don't have a strong opinion, but it's worth taking another quick look.
Great.
Agreed.
So this is Noelle. So the relevant language is from the APA, but that's just that, not committees, agencies have to consider all relevant comments, but the significant language is from the case law that agencies must respond to significant comments. So consider relevant, but respond to significant.
It's a fair point. That's a fair point. Actually, I in that light, I'm willing to withdraw my comment if significant, it sounds like corresponds better with the case law as well as I guess what we've said in our past recommendations. So if we want to revert back to significant, I think that's fine.
Jeremy, why don't you just put a note here or a mental note just to check to see the characterization in our, I think it was the mass comments one, though I'm not entirely sure. We probably try to be consistent if we can. That's my recollection of significant, but that's all it is.
Great. We will check on that, and whatever the recommendation the case law says, we'll use that term. Great. This was from Eric Womack at DOJ. He's not on the line, but Leslie, I believe you are. As I recall, the concern here is, of course, when is a rule final? When does a final? This has to do with basically when does judicial review begin? To avoid the issue, really what we're talking about here is when is work on a rulemaking project complete for agency personnel. I don't think I was trying to make a point about when opportunities for judicial review begin. Is there any objection to changing a final rule and the rulemaking project as a whole is complete when the agency official signs it, changing that to, for most agency personnel, work on a rulemaking project is complete when the agency official signs the final rule. Any objection to that revised language? All right, hearing none, I'll accept. Any objection to changing once to after? Assuming none, I will accept. Changing people to the public, which I believe is correct. No objection, I'll accept. Stylistic, absent an objection, I'll accept. Among other things, which of course is accurate. So hearing no objection, I will accept that. All right, so here the original sentence, and this is sample language to help, sample language offered to agencies. The original sentence was, to make its decision, the court considers the whole record of the rulemaking, which consists of materials that the agency created, received, and considered before issuing the final rule. Noel, you suggested changing it to make its decision, the court considers the whole record of the rulemaking, which consists of all non-deliberative information that the decision maker considered directly or indirectly in developing the final rule. Any comments on that? Any objection to Noel's revised language?
I think to the extent, I would prefer that all non-deliberative information be removed because, I think to the extent that there are courts that have excluded that from the record, that is an interpretation of what considered means. So I think that that's already included in the considered part.
Sure. So
And I think that the considered directly or indirectly is what I understand the standard to be.
So it would read, which consists of information that the decision maker considered directly or indirectly developing the final rule.
I would prefer that.
Sure. Any objection to that language? All right, hearing none. We'll accept. All right, here the original sentence is, after considering the whole record of the rulemaking and arguments made by the government attorneys and the person challenging the rule, the court will decide whether to uphold the final rule or remand it, send it back to the agency for further action. Adina, you recommended adding in vacatur. I have revised the sentence here to read, the court will decide whether to uphold the final rule, remand it, send it back to the agency for further action, or vacate it. I guess as a question to you, Adina, does that work for you?
That works for me.
Great. Any concerns about this language or objections to adopting it? Hearing none, I will accept that. I'll also note that this language, I believe, or similar language appears in a couple other places. We'll make sure that's consistent throughout the document before circulating it after for a vote after this meeting. Here, there is a reference to the rulemaking record, including all significant materials that agency officials create, review, receive, or consider during the rulemaking. Adina, you noted that there are a few places in the handbook where we use adjectives to describe the material that should be in the record. You worry that will lead agency personnel to think that only materials that were heavily relied on need to be included. Is there another adjective instead of significant that works here? Would you leave it as all materials? Can I turn to you first, Adina? What is your preference?
I think we discussed this last time and talked about potentially relevant, but then I think some people may have had problems with relevant, thinking that sounded too much like a legal standard, like a standard that would be used sort of in a court case. So sure. I'm curious what other people think.
What do others think? Significant, relevant?
Would responsive be broader than relevant, maybe? I'm just wondering if that maybe is a little further, just at least a half step away, because I definitely agree we don't want to make it look as though only the most relevant things should be in there. There are going to be things that are more on the edges, but so yeah, I don't know, maybe it's just in my own head, but responsive feels like it might be at least that half step outward that might help.
This is Dawn Goldstein from the NLRB. Responsive sounds like a FOIA request or a discovery request, which is not really what we're dealing with here.
Any other thoughts?
Yeah, this is Leslie Vegan from DOJ. I'm proxy for Eric Womack today. So Jeremy, is it all right for me to add in
Please.
what and channel Eric? I just agree that we should try to avoid language that sounds too much like the standard for a court proceeding, particularly a court proceeding like responsive just calls to mind discovery to me. And this is not discovery. And so I weigh in on the side of not including that term.
I mean, this is Dawn again. I mean, what we've confronted is we have a lot of personnel working on rulemaking, and we sort of hone in on key decision makers as opposed to every agency official.
So would it be enough then to say the rulemaking record includes materials or all materials that key agency officials create, review, receive, or consider during the rulemaking?
I think that's fair.
How does that sound to others?
This is Leslie again, Jeremy. I wonder if there would be benefit to just using the same language we've used previously, consider directly or indirectly, because I think that's pretty well accepted.
Sure.
Yeah, actually, I was gonna say the same thing. It's just because then when we get to the key agency officials thing, you get into the possibility that someone will only think that things that, for example, only things that the secretary or the deputy secretary saw count. And so I think the directly or indirectly helps with that.
So the rulemaking record includes all materials that the agency directly or indirectly considered during the rulemaking. Any concerns about that language?
Well, I think it would be the agency decision maker, but
Yes, that would make me happier.
Any objection to that?
I mean, I just worry because especially later, I think we talk about the agency decision maker being the agency head. So I do worry that that sounds like it has to be, sort of the secretary or someone like that.
What about key agency? Go back to using key agency officials directly or indirectly considered.
What about something like agency officials with substantive responsibilities for the rulemaking?
And I think that is exactly the language ACUS is used to refer to what consideration means. Any concerns with that language? Any objection to it?
One question, does agency official as opposed to sort of agency personnel make a difference? Like, will people interpret
like who is
official
an official versus a non-official and just personnel? Does personnel work as a good, I've used it certainly as an umbrella term throughout here for sort of anybody within an agency. Is that acceptable to others?
I think it's fine. I always struggle with this one. I don't mind officials. I don't think it necessarily connotes an officer under the, the constitutional provisions, but I think personnel is fine.
Great. So any objection to this sentence reading? The rulemaking record includes all materials that agency personnel with substantive responsibilities for the rulemaking directly or indirectly considered during the rulemaking. That last during the rulemaking might be a little bit redundant, but any objection to that sentence?
I mean, I'm sorry to be a little bit of a stickler here. I'm just wondering if instead of substantive, it should be significant, because we have a lot of people throwing things into the pot that may never rise to even medium level decision makers.
I think ACUS has used substantive. Not that has to be the end all be all for this, but Are there any other concerns with substantive? All right, hearing none, we'll go ahead and accept this. Again, I will circulate this afterwards. We can all take another look at this before we finally vote on the end product. Great. Here we get into the same issue. Adina, you raised concerns about starting the paragraph on page 17 by discussing information specifically seen by the agency head, since I expect the agency head is generally not the one reading the underlying studies, et cetera. What I propose in response to that, I hear that concern, is simply just dropping in a block quote from ACUS recommendation 2013-4, which states that considered entails review by an individual with substantive responsibilities in connection with the rulemaking. To say that material was considered also entails some minimum degree of attention to the contents of a document. Thus, the rulemaking record need not encompass every document that rulemaking personnel encountered while rummaging through a file drawer, but it generally should include a document that an individual with substantive responsibilities reviewed in order to evaluate its possible significance for the rulemaking, unless the review disclosed the document was not germane to the subject matter of the rulemaking. Given how difficult this concept can be to explain, are there, first of all, Adina, does that satisfy your concern?
Yeah, that works for me.
Great. Any objection to that or any concerns about that? Hearing no objection, I will accept this language. Great. And I think this is a similarly related concern. So originally this said, to that end, it is important for personnel to include all materials that the agency relied on or seriously considered in formulating its proposed or final rule. Is it better to leave that as the agency relied on, or should it read something more broadly as the final decision maker, high-level advisors, and other personnel with substantive responsibilities in connection with the rulemaking? So this is the agency doing the relying versus these other officials doing the considering. Any thoughts? Is it enough to just say the agency relied on in this case? All right, let's revert back to the earlier language, I think. Adina, this is a similar concern to before. Here we say relied on or seriously considered. Seriously raises some of the same issues as significant. Given how we've defined considered, is there any objection by any members of the working group to just saying considered here? Adina, would that work for you?
That would work for me.
Any objection to that? Great, we'll accept that. Here, this refers to materials that ordinarily belong in the rulemaking include other materials required by statute, executive order, or agency rule to be considered or to be made public in connection with the rulemaking. Noel, you wrote, the considered standard applies to the administrative record for judicial review. ACUS should confirm that the same standard applies to the internal rulemaking record, which is potentially broader and may need to contain documents aside from those considered in order to comply with federal record keeping obligations. I did double check recommendation 2013-4, which states that the internal rulemaking record should include other materials required by statute, EA, or agency rule to be considered, and any other materials considered by the agency during the course of the rulemaking. Noel, is there other language you would prefer to use here?
Well, I'm not a records expert in terms of the federal records. And so that's why I didn't really want to provide language because I didn't know that it would have been, preferred language, but I was just sort of, I mean, it sounds like you looked into it, so that's fine. I was just sort of flagging an issue.
Okay. Is there any other concerns by any other members of the working group with the use of the word considered here? Not, we'll retain it. All right, this section 4.2 provides reasons for why personnel should compile or what the purpose is behind the public rulemaking docket. Noel, you suggested adding in a sentence, the guideline should also explain that personnel compile the rulemaking docket to ensure that the public has adequate notice of any meaningful opportunity to comment on the rule. That looks like good language to me, and it's obviously an important point. Is there any concern with adopting that language? Any objection? Great, seeing none, I'll accept that. The last line is can result in legal consequences, changing that to adverse legal consequences, which I think that is a good change. Any objection to adopting adverse here? Seeing none, I will accept. That is a grammatical thing. Stylistic here. This sentence originally read, for example, some agencies only make copyrighted materials available for public inspection in the agency facility. It was suggested that we strike to avoid any potential legal liability for publishing them online. Any objection to that change? Great, I'll accept that. This paragraph refers to the guidelines addressing any special policies for handling materials that cannot be displayed in an online docket management system or are difficult to display in an FDMS. The last sentence reads, especially large digital files or databases may also pose challenges. It was suggested that we either elaborate on this or remove it. Given that we already provide examples of instances in which of special policies, is it necessary to include the sentence? Is there any objection to just removing the sentence? All right, hearing none, I will remove that. Same as before. Here, this refers to the critical factual material, the Portland cement principle. This refers to which studies and reports agencies should include in a public rulemaking docket. As originally drafted, the sentence read, examples of critical factual materials include important technical studies, staff reports, data, and methodologies that are not publicly available elsewhere. Adina, you said, I think it might make sense to add a qualification to the reference to methodologies that are not publicly available elsewhere to make clear that they should be included in the docket unless they are easily accessible elsewhere. Would it work to say methodologies that are not easily accessible elsewhere for members of the public?
That works for me.
Any objection to that language? Great, we will accept that. Stylistic, hearing no objection, accept. Stylistic, grammatical. All right, this regards adding privileged materials to public rulemaking docket. As originally drafted, it read agencies can but are not required to withhold materials covered by the attorney-client privilege or other privileges. However, it can sometimes be beneficial to include these materials in the public rulemaking docket. Is there any objection to changing that to, although it may sometimes be beneficial to include these materials in the public rulemaking docket, personnel should ordinarily consult with an attorney before doing so? Hearing no.
I mean, it goes
Oh.
without saying, but you could say an agency attorney. Or agency counsel.
Any objection to that language?
Yeah, Jeremy, this is Leslie,
Sure.
channeling Eric, because
Please.
we discussed this concern. I think part of the concern we had was with the idea that agencies sort of writ large are able to waive the attorney-client privilege. And that, term may include, as written here, could include agency personnel who may not actually be authorized to waive that privilege. So I think I would still suggest some revisions to that first sentence. Agencies can but are not required to withhold materials covered by the attorney-client privilege. Really, the issue is just to be clear that it's really a decision of counsel whether or not to waive privilege. That's sort of the intent of the comment that we provided.
Sure. Do you have any language?
I can think. I don't have any
Sure.
right off the top of my head, but I'll consider.
Perfect. Why don't we come back to this then? We'll return to this later in the process. All right, this is mostly stylistic, changing a knowledgeable attorney to the appropriate attorney. We'll presume all attorneys are knowledgeable. At least appropriate attorneys are knowledgeable. Changing comments to submissions, referring to materials received in the public. I think that's more accurate. Hearing no objection, I'll accept. Stylistic change, changing First Amendment principles to requirements arising under the First Amendment. Great. So now we've moved into the administrative record for judicial review, section 5.1. What is the administrative record for judicial review? As drafted, it currently reads, the guidelines should explain that the administrative record for judicial review is the compilation of materials that the agency certifies and provides to a court as the record on review of the agency's final rule. Adina, you wrote that the explanation in this section appears somewhat circular. It would be helpful to get the concept of the whole record in there. Can I turn to you first, Adina? Do you have any thoughts on language that would work here?
Well, I know that this section, that there's a later section that talks about what should be included. I just felt that the section sort of said that the administrative record for judicial review is the material that the agency certifies as the administrative record for judicial review. And I wasn't sure kind of how helpful that was.
Sure. It's tautological. Yeah.
I thought it might be helpful to say, that, I haven't drafted language.
Sure.
But maybe is, that the record that courts use as the record in assessing, in considering a challenge to a rule, and that it consists of the whole record before the agency, something like that.
I think that makes sense. We can work on the language. Any concern about that? Any additional thoughts?
The one other thing with this that I thought of, and I mean, it's sort of, we've been talking about rulemaking this entire time, but if it would be, maybe we should say something like final rule or agency action or something, just because an APA case with an administrative record does not necessarily mean a rulemaking or even that a publication to the Federal Register has occurred. It can be literally just a decision of the agency that was made. So, so yeah, that's my only thought, is to remind them that this is not just about rulemaking.
Or perhaps because this is a guide to, with regard to informal rulemaking, that some of these principles apply more broadly beyond just informal rulemaking. Something like that. Any thoughts about that, or any of these points? All right, in lieu of trying to draft the perfect language on the fly, why don't we take this back on the ACA staff and draft some language, and we can circulate that for review after today's meeting. Great, in 5.2, why do personnel compile the administrative record for judicial review? As drafted, it reads, the guidelines should explain the agency compiles an administrative record for judicial review to demonstrate the legal adequacy of a final rule during the judicial review process. Adina, you raised the point, a good one, I think. I would frame the purpose of the record slightly differently. I think it is to allow the court to assess the legal adequacy of the rule rather than to allow the agency to demonstrate the legal adequacy of the final rule. I think we can fix that by taking out demonstrate and making that allow the court to assess. Does that work for you, Adina?
Yep.
Great. Any concern with that language? Any objections? All right, hearing none, I'll accept that. Stylistic, I think, but no objection, I'll accept. All right. Section 5.5 is what materials belong in the administrative record for judicial review. I had called out language from guidance previously issued by NOAA. Adina, you had said the sample language here seems to be overly focused on showing the agency acted legally, as opposed to providing the court with the full information it needs to assess whether the agency acted legally. Megan, I see your hand up, and given where you work, I'm sure you have a response as well. Let me turn to you first.
Actually, it's about the previous section, 5.4.
Oh,
with a side note that I'm very sorry that mid-November snuck up on me and I yelped when I saw that this meeting was today. 5.4, I just, the sentence says the guidelines should explain that the agency only needs to compile an administrative record for judicial review if someone files a lawsuit in federal court challenging a final rule. If we could work in language, if someone files or it's reasonably anticipated to file, because we sort of treat it similar to the litigation hold standards in my office, where it's maybe it hasn't been filed yet, but you know this is coming and you should get a jump on it. Frequently, you don't need to wait for the lawsuit to be filed to be starting to think about these things. So I just know that especially if we're dealing with non-attorneys looking at this, there's the possibility of it becoming, oh, well, I don't have to worry about it then.
sure. So perhaps changing it to the guidelines should explain the agency only needs to compile an administrative record for judicial review if someone files a lawsuit in federal court challenging or a final rule, or it is reasonably anticipated someone will file such a lawsuit. Is that what you're thinking, or
Something like that, yeah.
or like or it may be advisable to begin preparing an administrative record if a lawsuit is reasonably anticipated. Any preference, or?
I think I liked the first way better, but I defer to anyone else. It's not a
Sure.
strong feeling.
Any other thoughts?
Yeah, Jeremy, this is Leslie. I have one other thought on this point.
Sure.
Just to make clear that this is an agency decision and not a legal standard, perhaps that could be, guidelines should explain that the agency should articulate its policies for when it begins to compile the administrative record for the judicial review. For example, when someone files a lawsuit in federal court challenging a final rule, or it is reasonably anticipated that someone will file such a lawsuit, just to make clear that we're not talking about the legal standard here, but we're talking about what the agency's process is.
Perhaps that. The guidelines should explain the agency's policies for when it begins to compile the administrative record for judicial review. For example, when someone files a lawsuit in federal court challenging a final rule, or it is reasonably anticipated that someone will file such a lawsuit.
Right. Thank you.
Thank you. Any concerns with that? Megan, does that work for you? Great. Any objection to that? Hearing none, I will accept it. Great. So Adina, let me turn back to you on 5.5. Your concerns about the language here. As I understand it, it was the same as the concern announced before, that it focuses more on the agency demonstrating the legal adequacy of its rule versus providing a record for the court to independently assess the legal adequacy of the rule.
Right, it is just sort of the same point that, I viewed the record more as allowing the court to determine whether the agency has done these things. I do think, though, it's just a framing question. So, if there are examples that don't have that frame, I personally would prefer them. But I don't know, if you want an example here, I don't know whether or not that's possible.
Yeah, I think unfortunately we have a limited data set of existing examples, which is a big reason for this working group being convened in the first place. One possibility is that I can try to draft sample language, perhaps with your assistance, Adina, after this meeting and circulate it to the group for review. Is there any objection to removing this example for now, and we can see if we can draft sample language to include instead? All right, hearing none, let's try that route. Great. So this is the same section, I believe, what materials belong in the administrative record for judicial review. This paragraph explains the guidelines should explain that agency attorneys or DOJ attorneys may ultimately decide not to include some materials related to the rulemaking in the final version of the administrative record filed with a court. There are several reasons why that might be the case. The last sentence currently reads, federal law may protect it from public disclosure, for example, or the material may be classified, confidential, privileged, deliberative, or pre-decisional. Adina, you wrote, stating that a lawyer may decide to exclude material because it is deliberative or pre-decisional seems close to saying that the information does not need to be in the record. Given that courts have taken different views on that, it seems easiest to me to leave those examples out. If we do that, the sentence will read, federal law may protect it from public disclosure, for example, or the material may be classified, confidential, or privileged. Any comments or concerns on that revision?
I agree with the revision. I think privileged covers that. sufficiently. At
Great.
least, you know, for the general terms.
Great. Is there any objection to removing deliberative or decisional? All right, hearing none, I will accept that change. This was from Eric and Leslie as Eric's proxy today. As previously written, it said the guidelines should also provide instructions for preparing an index of the contents of the administrative record for judicial review, as well as a privilege log, which describes and provides definition of privilege log. Eric and Leslie, you suggested an if necessary or if warranted, just given sort of current case law on this matter. Any objection to this language? All right, hearing none, I will accept. This regards the process for certifying the administrative record for judicial review. I had pulled an example from DOI's guidance. Leslie, correct me if I'm getting this wrong, but DOI's guidelines provide a rather elaborate certification process that may not be representative, instead of to prevent providing the to avoid giving the impression that we're suggesting the agency should adopt this particular process, we can safely remove this example. Did I get that right, Leslie?
Yeah, I think the main concern was to avoid suggesting that the must language in here is not the agency saying must, but is court saying must. So just to avoid confusion on that score, we suggested that this example be removed. Obviously, agencies can have whatever internal procedures they want, but I think our concern was that that folks not be confused about this being the legal standard for preparing an administrative record.
That's exactly right. Great.
Rather certifying an administrative record.
Perfect. Thank you, Leslie. Any concerns with removing this or any objection to removing it? Hearing none, it is gone. And I believe that is it. Before we conclude today, one second, actually, I believe there was one more point we're going to go back to. It was the section on privileged materials, as I recall. Leslie, maybe I can contact you after the meeting. We can figure out language, and we can include that with the version that we circulate to the broader group after the meeting, if that works for you.
Yes, that's fine. And before you end, Jeremy, I had one other small comment that we did not raise on our call, but I want to give others the chance to say anything or for you to go wherever you were planning on going before I jump to that.
No, please, you have the floor.
So at least on page 17 and possibly in other places, the term ex parte communications is used to describe communications about a rule with non-governmental parties. And I understand that I think it's recommendation 2014-4 uses that term. But we had a slight concern that there's a negative connotation associated with ex parte communications in the realm of judicial review or in the realm of sort of judicial proceedings. And the recommendation has a sort of nuanced explanation, recognizing that, but explaining that these types of communications are not problematic in the rulemaking context where agencies are appropriately seeking public input. So I wondered if it might make sense to either include a footnote with some of that nuance from the first page of that recommendation, or just getting rid of that term in this context if you don't want to go through the rigmarole of explaining that. I think that the term is fine used in the recommendation because the sort of the negative connotation is addressed and sort of put to the side. But I just we had that slight concern about that. Pretty minor point, I would think.
Yeah, I think that's fair. I think ex parte communications is used as a sort of shorthand among attorneys versed in these matters and maybe not elsewhere. Would it be good enough to say communications with persons outside the agency, outside the individuals outside the agency, something like that?
I think that would be fine. Or like I said, just adding to footnote 20, a quick disclaimer, something along the lines of what's in the first page of the recommendation itself, just saying, these communications are not problematic in this context, or something to that effect.
Sure.
The easiest fix here, I don't know if there's an easy alternative. That was one of the things I think the committee struggled with on ex parte conducts. I mean, you could do it sort of allegedly suggesting, and just if we can't come up with an alternative, just say, you could say this adds words, but policies on what are sometimes called ex parte communications, and then just have, unfortunately, a footnote just explaining that this the particular reason that phrase is used, and the somewhat misleading nature of it, given that it's really a term that's used in adversarial, judicial, and adjudicative proceedings generally.
That seems right. Okay, I think we can make that change. And if we're just I will just literally copy and paste the language from 2014-4, perhaps with some fiddling for stylistic reasons or grammatical reasons. Is there any objection to using the say ex parte communications policies on what are sometimes called ex parte communications, and then in footnote 20 or wherever else this appears, just using the explanation from 2014-4?
That sounds right to me. Thank you.
Great. All right, hearing no objection, we will take care of that before we circulate the next draft. Great. So as I said earlier, the plan is to circulate this, a clean draft, for review by the entire working group soon, hopefully, probably next week, I guess. And at that point, we can take a vote as a working group on adopting the handbook, which would conclude the process. Certainly, if you have additional comments between now and then, feel free to send them my way. I may be in touch with a couple of you about tweaking some of the language based on your suggestions. But before I end today's meeting, does anyone else have any additional thoughts, any general comments they'd like to share with the group?
Thank you for all your work on this.
Thank you all for participating. This has been a fun 2-year process, and I'm very happy with the product we're ending up with. So thank you all for all your help throughout this process.
And Jeremy, just might want to point out now that we'll find some, I don't know if it's adequate expression of appreciation for everyone's effort, but at least an appropriate one. And I'm sure that when we publish this, so to speak, we'll issue some kind of release, and we will identify the members of the working group in the release with appropriate disclaimers, obviously, especially for agency officials.
Absolutely, absolutely. And to that extent, please take a look also at the beginning where I list the members of the working group. If you or your agency should be listed differently, please just let me know, and we will make that change. Great. Well, if there's nothing else, thank you all. We may or may not have another meeting. We hopefully can resolve all of this by email. But again, thank you all so much for your work throughout this process. It's been a true pleasure working with all of you. Thanks.